way is it?
All right, we will go ahead and call the House Judiciary Committee to order at this time. We will begin the meeting with a prayer, as we always do. If y'all would like to join me in prayer. Dear Heavenly Father, we thank you for this opportunity to work on legislation today, work on behalf of the people of the state of Georgia. We pray for peace in Ukraine, that you look after the victims of the attack there, and that ultimately this war is resolved, and that happens immediately. In Jesus' name I pray, amen. All right, we have one bill on the agenda today. I've received a few questions about it. We'll be hearing only today. We have a few witnesses who are signed up, and I know that there's been a fair amount of discussion about the legislation. At this point in time, we'll go ahead and call up Senator Dolezal to present SB 393. Senator, if you just want to have a seat here in the witness chair and take any time you need to set up, and then the committee will hear from you. Thank you.
Thank you, Mr. Chairman, members of the committee. I'm not sure I've ever sat in front of this many lawyers in my life, so forgive me if I'm nervous. I want to talk to you all today about Senate Bill 393, and we're working off of LC 365075S as it passed the Senate. And what I'd love to do is zoom out and talk big picture for a second, and then I'll walk you all through the bill and then be happy to answer any questions. I know there's some folks here that want to testify as well. Big picture, what this bill does is it establishes social media companies with more than 20 million users as common carriers, and states simply that they cannot discriminate based on viewpoint, gender, religious expression, etc. The Supreme Court in 2017 in the Packingham versus North Carolina case described social media companies as the 21st century public square. So in my mind, I think about it the same way that I think about the steps of the Capitol, and we'll use some examples today to talk about that. But with that establishment, then another Supreme Court justice opined in some dicta in Knight versus Biden that social media companies could be treated as common carriers. And the idea of common carriers goes back to English common law, and it states that by the nature of near monopoly status, that a common carrier is determined, not by their declaration of being a common carrier, but if they have near monopoly status, that they are a common carrier. And common carriers that we would know of today would be things like the airlines, the railroad companies. Initially, they started out as things like couriers, and then obviously in modern technology 20, 30 years ago, cable companies and telephone companies were established as common carriers as well. So the common carriers provide a public function or public accommodation, and they tend to have market dominance or near monopoly status, as I mentioned earlier. Common carriers, and this is important, are still allowed to make regulations and even exclude participation based on reasonable grounds. What we are attempting to do in this bill is to eliminate viewpoint-based censorship. Social media companies can still prevent pornography or other lewd material. This bill would stop viewpoint-based censorship, but would not prevent other standards or censorship being applied. You've heard about, I assume at some point, if you've read about any of these laws that have passed in Florida or Texas, certainly if you haven't, you'll hear today about Section 230, the Communications Decency Act. And we'll outline a little bit of what 230 does and what it does not do. What you'll also hear about is primarily 4 to 5 Supreme Court precedents, a few of which will be used to argue against this bill, and some of which we can use to argue for this bill. Tornillo is a precedent that folks will use to argue against this bill. And in that case, a newspaper had published an editorial about a political candidate, actually, and that candidate wanted to respond with an op-ed, and the Supreme Court ruled they did not have to publish the op-ed because as a publisher they had free speech rights. The Hurley case allowed a parade to exclude who would be able to participate in the parade. So those are 2 cases you'll likely hear about today. 3 cases that support what we're trying to do here. One of them is modern day. You may remember this in the Rumsfeld case, where the military was trying to recruit at law schools, and the law schools were trying to prevent the military from recruiting there on the grounds that they didn't agree with that form of speech, and they were compelled by the courts to host the military recruiting on their premises. Pruneyard is a case that required shopping centers to allow protesters to hand out pamphlets, And the court ruled that, quote, "The view is expressed by the members of the public in passing out pamphlets or seeking signatures for a petition will not be likely to be identified with those of the owner." And then something that we all can relate to, because all of us probably have cable television, Turner Broadcasting. Cable companies were forced to carry local broadcast signals even though they did not want to. And that was largely based on the common carrier precedent. So those are a few court precedents. I'm happy to expound on those. But in the meantime, Mr. Chairman, before we do that, I'd love to just walk through the bill and talk about what the bill does. Lines 18 through 37, we establish what a common carrier is. And in this bill, this falls under the code section of the Public Service Commission, who would have oversight of the implementation of this law. Lines 83 to 92 is the meat of the bill. It outlines censorship, and it outlines censorship based on viewpoint, geographic location, race, color, ethnicity, religion, religious beliefs, political affiliation, national origin, sex, gender, sexual orientation, or disability of the users. Lines 104 through 115 really applies where the scope of law is to be essentially within the state or to communication that happens within the state. Lines 121 to 132, I would probably say, is the second most important part of this bill, and it outlines what is allowed to be censored. So things that are allowed to be censored are obscene material, lewd material, filthy material, etc. So things that we would still want to happen if we wanted our children to be on the internet. Lines 135 to 157 provides transparency to ensure compliance. Lines 159 to 181 provides for a biannual transparency report whereby the common carriers would state the number of complaints they received, how they acted on those complaints, etc. And then lastly, lines 183 to 193 is the enforcement provision, which does include a private cause of action for those who are discriminated against by the common carriers. With that, Mr. Chairman, I'd be happy to take any preliminary questions, or if you'd prefer to hear testimony from others, I'm happy to do that as well.
Senator, you expressed concern appearing before this many lawyers. With all the case law you decided, maybe we'll give you honorary lawyer status here today. You may not want that. I don't know.
I'll take it. I'll take it. I hear y'all make a lot of money.
The questions that have been put to me, if of course, this issue's been in the media quite a bit, and if there's the ability of someone who is dissatisfied with an existing social media network to create or join a different network that has different levels of restrictions concerning speech, or maybe a different approach to whether speech is suppressed on those platforms, is it truly a common carrier, or is common carrier consideration appropriate? Does that reach that near monopoly status that you were referencing?
Yeah, it's a great question. And in the bill, we do establish social media companies as those with over 20 million users, because we believe that scale is where you reach that near monopoly status. In full transparency, that's a somewhat arbitrary number. Texas and Florida had 50 or 100 million respectively, I believe. So we're all kind of landing in the scale at which we believe that in order to fully participate in public life, to be able to fully communicate in the 21st century public square, that you need access to these tools should you wish to have them, because your ability to espouse your views on those platforms, as we have seen, is something that is essential to participating in modern day life. Are there other platforms that exist? Absolutely, there are other platforms that exist, but they do not have the scale or the near monopoly status, in my belief, that would establish them in such a way that would say that in order to fully participate in the 21st century public square, that you need access to, Jim's social media company that has 500 users versus something like Twitter or Facebook, which is ubiquitous in our culture.
You referenced, Senator, similar legislation in Texas and Florida, which has been put under the First Amendment scrutiny to determine, just whether state statutes appropriate or in conflict with the First Amendment, in consideration of the First Amendment. And I guess my question is, do you anticipate case law, greater guidance from the courts coming in the next few years as to where there is or is not conflict with the First Amendment and state statutes in this area?
I do. I think we're going to see that, particularly with the Texas case. I would say this bill more aligns with the Texas bill than it does the Florida bill. The Florida bill spoke specifically to deplatforming of publicly of qualified political candidates. We don't deal with any of that in this bill specifically. It would fall under the viewpoint-based censorship, but we think a bill that more appropriately protects the free speech of all Georgians is appropriate. There's a quote that comes from Justice Breyer that I think is interesting and applicable, that he was joined by Justice Ginsburg and Sotomayor, and they stated the quote, "Requiring someone to host another person's speech is often a perfectly legitimate thing for the government to do." So we have seen Clarence Thomas in the Knight versus Biden case laid out the framework for this common carrier path that we are following. But we also see Justices Breyer, Sotomayor, and Ginsburg laying out the path for the concept of forcing somebody to host somebody else's speech. So this is definitely something that I think, to answer your question succinctly, yes, I think the courts are going to continue to deal with this.
All right, thank you. There are a few questions. Representative Walensky.
Thank you, Chair. I'm just, first, as a common carrier in Georgia, can you give me, I understand, I guess, the Postal Service, the train service, even FedEx, gas companies. What are other broad examples of common carriers in Georgia?
Telephone companies, cable
Okay.
companies. I don't know if you mentioned those or not, but airlines
Okay.
would be as well.
All right. And clearly none of those deal with speech per se. It's just literally the physical movement of goods or people.
Certainly the cable companies do deal with speech. The telecommunication companies deal with speech. So in the Turner case that I referenced earlier, what we saw was the courts forced Turner to host speech of the publicly, of the local news networks that they may not have wanted to host, or that they did not want to host, and they were compelled by the courts to host that speech.
What can you tell me what happened in that, more specifically, what speech was?
So the cable companies wanted to provide just the broadcast that they wanted to provide, right? They wanted to have control over that transmission, and the courts ruled that they needed to carry local broadcast channels in addition to that, regardless of what the public, regardless of what the language, not language, but what the viewpoint was of the local cable companies that they were forced and compelled to.
So it sounds
to
like you're
host.
saying the case was actually about forcing them to carry certain channels. It was about whether they should
Certain broadcast signals, correct.
certain channels.
A broadcast signal that they would put on a channel, yeah. It's a slight distinction there, but yes.
And so based on that case, are cable companies not able to choose what channels they do and don't? I mean, I just lost Fox Sports or a sports channel. Why is that allowed based on that case? Do you know? What the
Why is
difference
Fox Sports allowed?
Or like, I have,
The case would more so have applied to your local broadcast channels.
Okay.
More so than Fox or other existing cable channels.
Okay.
And I would love to read for you a section from that case if we have time for it.
No, I don't know. It's up to
Because
the
it
chair.
underscores this and unpacks it pretty well. It's just
Yes, please, go ahead.
paragraph and a half. And in my mind, I think that, well, anyway, when an individual subscribes to cable, the physical connection between the television set and the cable network gives the cable operator bottleneck or gatekeeper control over most, if not all, of the television programming that is channeled into the subscriber's home. Hence, simply by virtue of its ownership of the essential pathway for cable speech, a cable operator can prevent its subscribers from obtaining access to programming it chooses to exclude. A cable operator, unlike speakers in other media, can thus silence the voice of competing speakers with a mere flick of a switch. The potential for abuse of this private power over a central avenue of communication cannot be overlooked. Each medium of expression must be assessed for First Amendment purposes by standards suited to it, for each may present its own problems. The First Amendment's command the government not impede the freedoms of speech does not disable the government from taking steps to ensure that private interests not restrict, through physical control of a critical pathway of communication, the free flow of information and ideas. Assuring that the public has access to a multiplicity of information sources is a government purpose of the highest order, for it promotes values central to the First Amendment. So that was certainly related to speech and viewpoint as they stated that in the Turner case there. But the underlying concept was as it related to the local channels.
Okay. On line 83, 84, just reading it, a common carrier shall not censor or discriminate against a user, and then skipping over the expression part, a user's ability to receive the expression of another person based on, if we jump to 4, the actual or perceived race, color, ethnicity, religion. I'm trying to understand an example of that where a common carrier censor, discriminate a user's ability to receive the expression of another person based on those things. Can you explain to me how that works?
Yeah, I think that actually the previous quote that I read underpins that pretty well, and that is that you're providing this conduit for the multiplicity, they call it the multiplicity of information sources. And so therefore, you cannot, based on the actual or perceived race, religion, all of the things that are listed there, because what we see, this is not being done by, a person behind a curtain necessarily that's individually looking at each post. It's done by the algorithm. So it's speaking to what the algorithm essentially is allowed to look at as you see things like shadow banning happening on the platforms.
To receive the expression of another person.
All right, we'll go ahead and move on and circle back. Oh, did
Yeah.
you have a follow-up question?
Yeah, I do.
All right, one more.
I mean, my biggest concern is speech and communication. The biggest thing we see with anti-Semitism is the use of national origin or race to be a reason that they claim it's not anti-Semitism and that speech is protected. And we've seen these platforms to really crack down on harassing and other ways of stopping. I mean, you call it bullying, but it's much worse. And we see the people that are most affected by social media are young children, and especially now, I guess it would be college students. I don't know if kids below college are using Facebook. I don't know what they use.
They're on the TikTok these days, I
The
think.
TikTok, the Snapchatter.
Right.
But I'm just trying to understand. My concern is that we are allowing these platforms in no way to stop harassment. And by allowing people to come in and make a claim that people are receiving the expression in a certain way, then that's okay. That's different than the way somebody says something, perhaps.
I would point you to lines 125 through 126, which explicitly does allow the platforms to prevent harassment. And so the way that this is going to work in the real world is they're still going to have standards of use and standards policies. But the example that I use, just because it's something we could all relate to, is that you could not, if I go out and espouse in front of the Capitol building, the earth is flat, I cannot be removed for that. However, if I go out in front of the Capitol building and threaten you, I can be removed for that. Similarly, what this bill would say is that on Facebook, Twitter, et cetera, if I espouse it's my view that the earth is flat, we can proceed and dialogue over why that is, an asinine belief. But I cannot be, the platform cannot shadow ban me or deplatform me based on stating something like that. The platform still, however, can deplatform you if you're harassing or threatening people.
One more question, Chair.
Go ahead.
So which would take, all right, so say it is that situation where it is harassing speech based on the lines you said, however they say, but no, it was based on national origin. Would that be okay then?
I don't believe it will be okay, and I'm not fully aware of these specific
Lines
reference.
83 says a common carrier shall not censor or discriminate against a user, and then it talks about based on national origin, right?
Correct.
So my concern is when there's harassment, but then the person receiving or giving the speech says it's based on national origin, that's a protection now. That's my concern.
So what you cannot do under the bill is say this person is, let's just say that they're from Europe. They're European, therefore we're going to have an algorithm that shadow bans content coming from people who are European. You cannot prevent you as a user from seeing what I write if I'm European. What you can, however, do is allow me to be deplatformed should I say something that is harassing to people of European descent.
Let me try to ask it one
helpful?
more time.
Sure.
If somebody is using harassing speech, but they have the defense that it's based on their national origin, that they're saying this, does that give them a protection to say we should stay on the platform because it's based on line 88, number 4, any of those things?
I would maybe need to see a specific example of the harassing speech that would be based on their national origin, but I believe that the social media platforms are allowed to have, I know that they're allowed to have standards that would prevent that.
All right, Representative Oliver.
I'm remembering, I think I'm correct, that Chairman Setzler had a long hearing on this Heritage Foundation promotion last summer, and that we discussed it. And from that hearing, I'm remembering a conversation, one, that the litigation is ongoing, being paid for by the citizens of Florida and Texas and should Georgia pay for the litigation too? But secondly, why am I telling Facebook, a private entity, what they should do with their decision to allow President Trump or Marjorie Taylor Greene to espouse false information on vaccines? Why should I tell Facebook that how they should control their product?
So I think that I would point you to somebody who I don't always agree with, and that's Senator Bernie Sanders, who stated, and I'm paraphrasing here, today it's President Trump, tomorrow it could be someone else. And I'm not comfortable with social media companies having, actually he said big tech, I'm not comfortable with big tech companies having that kind of power. And so to the extent that you would believe that the Supreme Court was correct that social media companies are the 21st century public square, and to the extent that you believe that this country should, its survival really depends on the vociferous debate of ideas in that public square, then you should say that we want to allow the debate for as asinine as a belief may be, such as the earth is flat, that we do actually believe that there's room in this country to discuss those ideas. And that I would also point you to the fact that we do this every day. We're already telling telecommunications companies what they should do, and they are regulated because of their near monopoly status or their essential monopoly status as it relates to the free flow of information.
You may not be aware, I've been in litigation about the public square across the street of Liberty Plaza on the rules about who can go there.
I'm not.
Well, it's interesting litigation, but it's resolved now. But anyway, it was interesting to me anyway. But I don't have to pay to go over there to the Liberty Plaza to talk about whatever I want to. I have to pay Facebook. I have to pay these channels, and it's a commercial activity that I choose to participate in. So I'm confused.
I'm not aware of a social media company that charges for the use. Certainly no social media that I'm aware of with over 20 million users charges.
It's a commercial entity, am I correct? It's a private commercial entity. It's not the government, yes or no?
That's correct.
Okay.
Yep.
And saying the earth is flat, I don't think hurts anybody. It's not an accurate statement, but I don't think people are going to be hurt. But saying to people, don't take the vaccine because you can ingest in whatever, and cure the non-existent COVID, that has the potential of hurting people. And you don't want Facebook to have the right to deny access to Trump or Marjorie Taylor Greene. That's the purpose of this bill, correct?
I would say that the purpose of this bill is much bigger than any single person. We've seen tens of thousands, actually millions of people who have fallen under some form of Facebook timeout, Twitter timeout, et cetera, for espousing their views, not only on the right, but on the left as well. And so this is something that we think that poses a threat to the First Amendment in this country, and that we think that the free exchange of ideas, even the ideas that you just expressed that I would disagree with, we think that the best way to combat those is with information, not with censorship.
Then I'll just end this, Mr. Chairman, by saying, as somebody who's pretty fiscally conservative and knows the cost of litigation, I don't want Georgia to participate in this litigation.
Thank you for your comments.
Representative Evans.
Thank you, Mr. Chairman. I held back in pushing my button because I'm still not sure of the question, so bear with me here. I have mixed feelings about how we do or don't regulate social media and how we do or don't let them control what comes onto their platform and what kind of responsibility we put on them, which right now is none. I mean, if I'm a defamation lawyer, you can't sue Facebook for what they allow to be out there. The media, you can. The media controls, NBC, CBS, they control what they let on their airwaves, and because of that, they have a duty to review and check for truth and accuracy, and then they're subject to lawsuits. What I find most problematic about this, in addition to the concerns that have been raised, is that you sort of want the best of everything for social media. You can't regulate it, and you can't be held responsibility. And so I'm just wondering what I'm missing here. In your mind, what's the difference between social media and media?
It's very simple. It's the publishing content. So let's talk about 230 for a second, and maybe a bit of a history lesson. Passed in 1996, back in the days of AOL and Prodigy. So if you remember dial-up internet and the crazy sounds when you were connecting. The social media companies, the internet companies at the time could have been held liable for objectionable or illegal material posted by you or myself because they were being treated as publishers, right? So they're being treated as the media, which is a publisher. So along comes 230 and says, no, you can still moderate content and not be held liable for, and I have it in front of me here, but basically the categories that it protected them from: obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable material. Now, what we're seeing in the courts is the social media companies are grabbing onto that otherwise objectionable, and judges are reading meaning into it that I would believe does not fall within the context of that sentence that I just read. So what you have is social media companies saying, we can censor because we're publishers, right? We're going to use our First Amendment right as a publisher to censor, but we're not going to be held liable as a publisher because of 230. So I think if anyone is having the best of both worlds, it's actually the social media companies who are claiming the protections of two sides of the law. Section 230 is something that certainly will be litigated to the point that was raised earlier, and maybe something that Congress deals with as well, because it's gotten into an area that I think most people believe is something that it was never intended to do. Is that helpful?
I think so. Yeah, I was just curious how you would compare the two, so that's helpful. Thank you.
Representative Fleming.
Thank you, Senator, for bringing this legislation. I had a question and then a thought when one of my colleagues mentioned the discussion of taking the vaccine or not, and whether or not we should have that, and if you're opposed to it, ought you be able to express yourself as to why. Today, on the House side at least, many people had on purple capes. I left mine at home. It's for lupus. One of our colleagues suffers from that. I've had conversations about that, and I learned that was one class of people that many doctors thought should not take the vaccine because of what it could do to the underlying condition that they have. So as many of us wore purple capes today, or would have if they'd remembered to bring them, I think this discussion about the freedom to have these discussions online and not to be banned because I think a vaccine is good and I got all three, versus the discussion that maybe you don't need to, and here's why. I found that ironic. But nonetheless, my question, I think, was a little more simpler than that. The chairman may have alluded to it, and I think you have a couple of times, but I just want to ask it directly. As I understand it, Florida and Texas legislatures both passed similar laws to this, signed into law by the governor, and now the courts are dealing with those. Is what we have in front of us, and you've already made one distinction I know of, is what we have in front of us pretty similar to exactly what Texas and Florida did?
It's very similar to Texas. It's in the same vein of Florida in that it establishes social media companies as common carriers. But the viewpoint-based censorship would be a distinction between our law and the Florida law that Judge Hinkle ruled on.
Do you know how many other states possibly are considering similar laws as this?
I'm not aware of that, no.
Do you know of any others that might be?
I know this is active conversation that's happening around the country, and to what extent that these bills are making their way through the current legislatures, I'm not exactly sure.
I was understanding that there were several, and that's why I was asking if you knew. So
Yeah,
thank you, sir.
yeah.
Appreciate it.
All right, thank you. Representative Holcomb.
Thank you, Mr. Chairman. Who could file a lawsuit?
So any person who has been, let me find the section of the code. I think it's the very last section. So any user who has been deplatformed, shadow banned, or otherwise censored based on viewpoint, religion, race, I think age is in there as well, et cetera.
Where are the lines to what you're referencing right now?
183, it starts at 183.
Okay. As I read that, it just states, if a common carrier violates any provision of this chapter, a user may bring a civil action against such common carrier. User is defined on line 80, and user means a person who posts, uploads, transmits, shares, or otherwise publishes or receives expression through a common carrier. So that definition doesn't match what you just said.
I would be certainly open to language if you want to make an amendment that would clear that up. I would be open to that.
So your goal is just those that have been removed from the platform?
There's multiple things that a social media company can do that would be a form of censorship removal, which often called deplatforming is one of those. Shadow banning is another one.
What does that mean? I don't know what
That
that
means
means.
essentially de-ranking you in the results. So you can make it so that all of a sudden, if say that you and I were friends, all of a sudden I never saw your content. That's something that we know happens, and it's a soft form of deplatforming, if you will.
Okay. As I read this, at least through the first time, it struck me as being really overbroad, because then if you look at user on lines 104, it says this chapter shall apply only to a user that currently resides in this state, makes sense, does business in this state, makes sense, or shares or receives expression in this state. I have a concern that that's very overbroad, because shares could be somebody who's traveling through a layover at Hartsfield, makes a post, leaves. Could be somebody driving down I-95 on their way to or from Florida, makes a post, leaves. But then the definition of user is those that receive. So it could just be somebody that receives or sees the post and is a follower or whatever, and not the person who is making it. So I think we need to nail down those details.
Yeah, I think that the receiving piece is important, though, because that is where we see a lot of the avenue for censorship being discoverable, as well as it's ultimately what the algorithm is doing. So it may allow me to still post my viewpoint, but it may make it so that essentially nobody sees it.
Okay.
But I'd certainly be happy to work with you on clarifying language that would be helpful for
Representative
improving that.
Holcomb, I think what would be covered by this shadow banning concept is the definition of censor, which is lines 45 to 53. But I understand you're interpreting these terms into other parts of the bill. I just wanted to mention that may, the type of suppression that was referenced, that might give you a definition for that.
Yeah, I understand, Mr. Chairman. I think what I'm thinking is just the application of this in terms of a potential private suit of somebody who might characterize themselves as a user and want to file cases in our courts, and who knows, social media stuff has a way of exponentially getting out of control, and there could be lots of cases filed. And just, does the state have an interest in people who don't reside here but are traveling through and post while they're in Georgia to then be able to file Georgia-based claims because they could say, I posted this while I was in Atlanta,
Yes, sir.
and then it was censored? That's the point that I'm driving at.
Yes, sir. All right, I see Representative Wilson has a question online. Representative Wilson.
Thank you, Mr. Chairman. Can you hear me?
Yes. Go ahead.
Senator, is there urgency to this bill?
In my mind, there's urgency to this bill, yes.
Is something you'd like to see us take up this year, I take it?
Yes, this is something I think that is timely, as we see more and more people relying on social media to exercise their First Amendment rights. I do think that this is something that is worth addressing this year.
I appreciate that. I note that in the conversation earlier, you've referenced this, and many other speakers have referenced the fact that the courts and Congress are dealing with this right now. You said that this bill is very similar to the bill in Texas that passed and is currently enjoined by the courts. And I just want to get an answer to Chairman Oliver's question from earlier. If this bill passes, it will be immediately enjoined and litigated. Why should Georgians have to pay the litigation costs? Why not wait and see what the courts say first?
So I think that in this circuit, the Florida case that Judge Hinkle ruled on is not. It's a cousin to this bill. It's not an identical twin. And so I think that what we're doing here with viewpoint-based censorship is something that that may or may not be enjoined. I think that your prediction could become true, but time will tell on that. But I do think that the First Amendment protections that we believe this bill provides is something that is a compelling interest for the citizens of Georgia to have protected by the state.
It's a value that's worth paying for.
I certainly believe the First Amendment is a value worth paying for, yes.
Would you consider it a tax?
Would I consider the First Amendment a tax or the process of defending the First Amendment a tax?
No, bringing this bill before the courts have made clear what the authority is.
I would not, Representative, with all due respect, consider it a tax, but I certainly appreciate your perspective on that.
Thank you,
All
Mr.
right. Next up, Representative Dreyer, who is online.
Thank you, Mr. Chairman. You're citing the Turner Broadcasting, the FCC decision, as part of the basis why this might be constitutional. But in that decision, Congress had undertaken 3 years of investigations and specifically determined that there was vertical integration, meaning monopoly status for these. And then in response, Congress undertook a nationwide solution to the problem that it was trying to address. And so when we're talking about the time, how urgent this is, the ongoing litigation, I mean, we're not on the same footing. I mean, as far as I know, Georgia has not undertaken and really is not in a position to undertake, like Congress would be, a 3-year investigation to lay the groundwork that this was a monopoly issue that would need a nationwide solution. I mean, I know that's a little bit long, but this process, let me just get down to the question. This process that for this bill is significantly different, both in terms of time, hearings, investigations, and regionality focused on Georgia based what Congress did that was addressed in the Turner v. FCC decision, right?
I don't know every step that was taken leading up to that decision. I do know that when 230 passed, however, Section E3 of Section 230, which is obviously what both of the cases that are enjoined have been enjoined under the concept of 230. Section 2 of 230 to be specific, but Section 3 of Section 230 specifically states that nothing in this section shall be construed to prevent any state from enforcing any state law that is consistent with this section. And so we believe that this law is consistent with Section 230 in that it does not hold social media companies liable for voluntary good faith censorship of lewd and obscene material. And so we do believe that there is specific room here under the law in Section 230 for the state to act.
Mr. Chairman, may I go with one more question?
Yes.
Thank you, Mr. Chair. And to put a cap on that last point, though you're citing a section, there has not been a intensive congressional investigation into the monopoly power of these social media platforms and whether there needs to be legislation. But that specifically gets to the point that Representative Holcomb was addressing earlier. There could be a national group funding litigation, and thousands of people could make posts in various states around the country and absolutely flood our court systems and make it impossible for some of these social media companies to operate. And I think it gets even more complicated because you talk about shadow banning. I mean, I bet a lot of people feel like some of their posts deserve more attention. I feel like my post on basketball deserve a little more attention. No one pays any attention to it, but I'm not shadow banned, and no one knows for sure in most situations if they're shadow banned. I mean, I'm concerned about widespread litigation in something that I don't think we've seen before. The amount could be so enormous. I mean, that's a fair concern, don't you think?
I do. I would point you, Representative, to lines 135 to 157, in which we would have visibility under this bill that we do not have today, to your point, of what the algorithms are doing. We would have visibility that I think would prevent frivolous cases, because we would actually be able to understand the actions of the algorithms as opposed to being in the dark on those. I certainly appreciate your input and concern, and I will just say this as well. I don't think that we can join via Zoom in the Senate, so I'm jealous that you all get to do this. I'm not sure how that happened, but thanks for joining us today.
Mr. Chairman, thank you for letting me express those concerns.
Yes, sir. All right, next up is Representative Bruce, who is on Zoom. Representative Bruce, if you'd like to unmute yourself, we'll hear from you now.
All right, thank you. Senator, I too share with you, I'm not an attorney either. I just play one capital. But I know that we're talking primarily about regulating or deregulating social media platforms. But now that a lot of schools are going towards allowing teaching from home and teaching on the internet, how does this bill interact with the other bill that the Republican Party is putting forward to stop teaching of Black history or American history in schools? Given that some of those classes may be taught on the internet or taught through these platforms, how do these two bills interact with each
Well, Representative, I'm not aware of a bill that my party's put forward that would restrict the teaching of Black History Month or slavery. I believe those are the two things that you mentioned.
Yeah.
And I'm not aware of how they would
Black
connect.
American history? I mean, it's the bill is I think it's in the Senate now. But
If there's a bill in the Senate that prevents the teaching of Black history or American history, I'm unaware of it, Representative.
okay.
All right, any follow-up, Representative Bruce?
That's it. Thank you.
All right. Yes, sir. Okay, Representative Walensky has one final question.
Thank you, Chair. I just want to start with, I'm also concerned how few views Representative Dreyer's tweets get, but I digress. No, but seriously, my concern is when, as a state, we start saying that any of our constitutional amendments are unlimited. Each one of our constitutional amendments have limits. First Amendment, Second Amendment, I can go through all the amendments. But so when we're looking at this and you look at freedom of speech, it deals with compelling government interest. And the government must show governmental action is necessary to achieve a compelling governmental interest to restrict freedom of speech. And one of those is protection of public health and safety. And I carried a bill last year or the year before, can't remember which one, they all blend together, but dealing with cyberbullying. The amount of suicides we have going on in Georgia due to cyberbullying, also through misinformation, all the, and it's not just young children, it's all ages. And my biggest concern here is that we are choosing to protect something when we're not protecting our citizens. We're not protecting our citizens from harassment. And I understand you said that line protects it, but then I'm still confused on how the two paragraphs, once again, section 4 correlates with that section. Can a person use defense of race, color, ethnicity, religion, national origin, sex, gender to say that they're allowed to say what they want to say? But my biggest concern is these platforms are doing a really great job these days of controlling harassing and harmful narrative. And I'm really concerned that why this bill has good intentions, and I have a good idea where it came from. I just don't think this bill is the right way to do it, because it will limit these platforms from really saving lives, saving people from being harmed. And I guess we could argue all day whether misinformation is good or bad, but it's not just misinformation. Sometimes it is really things that are on the line of threatening and harmful and really ruining people's lives. And sometimes it's not suicide. It can cause children to switch schools. It can cause children to leave college. It can cause children to drop out of college. So thank you for bringing the bill. I think it has a place in some way. I just don't agree with how we're trying to do it today, but thank you so much.
All right, Senator, we have 4 witnesses who have asked to speak. If you'd like to scoot over, we'll give you, as we always do, the sponsor an opportunity to respond at the end of the hearing.
Thank you.
Today. All right, first up is Elizabeth Banker, who is online.
Good afternoon. Thank you, Mr. Chairman and members of the committee. I'm Vice President of Legal Advocacy for Chamber of Progress. It's a tech industry association that works to ensure that Americans benefit from technological leaps. Our corporate partners include companies like Google, Meta, and Twitter, but our partners don't get a vote or a veto over our positions. One of our organization's top priorities is to promote safe and healthy online communities, free of hate speech, hoaxes, and disinformation. That's why we strongly oppose this bill. It would tie the online services' hands when it comes to the fight against toxic and incendiary content. And I'd like to note that much harmful content that occurs online is not actually unlawful, as it would be required to be to fall under the exceptions to this bill, where providers would be able to remove it without the risk of liability. I'd like to provide you with just a few examples of how this bill will impact the dozen or more social media services that will be covered. First, the bill will cause social media services to be overrun with disinformation and conspiracy theories through its ban on what it calls viewpoint discrimination. This would hobble platforms' constitutional freedom to remove or downrank things like Russia's lies and propaganda about the war in Ukraine. It would allow any person who has accessed the internet from Georgia to file a lawsuit to effectively prohibit Twitter, YouTube, and Facebook from removing obviously false claims by claiming it discriminates against their views. In addition, the bill will make it easier for bad actors, scammers, spammers, to evade detection by forcing companies to provide a roadmap for their terms of service enforcement efforts. Online platforms support transparency, but requiring detailed disclosures about things like how algorithms work can actually just deliver to bad actors a playbook for how to get around these protection measures that service providers have in place. And then finally, I would say one other thing to really think about is the impact that this bill would have on important safety tools that social media providers make available to people who are, let's say, victims of domestic abuse, cyber stalking, or other harassment. These include things like mute and block functionality. The bill's definition of shadow banning includes these types of tools and would essentially render them impossible, or at very least very dangerous, since an individual would have to be notified if the visibility of their content was being limited because someone had chosen to mute or block them. For the safety of our online communities, we respectfully urge you to oppose this bill. Thank you.
All right, there's one question. Representative Holcomb.
Thank you, Mr. Chairman. Thank you for your testimony. I have a technical question which gets to this issue on line 108 of the sharing and receiving expression in this state. I always turn off the location stuff. I'm not a tech person, but my question is, do all the platforms have the ability to determine where content was posted if there are jurisdictional questions like that, or would it be only if a person had that geographical aspect turned on? What I'm thinking through is just, would we have to litigate where these things are actually being posted and received, et cetera?
I think the ability of a platform to know where a user is in a particular moment of time tends to vary depending on where they may be and how the IP address, for example, gets assigned to that location. So it can be more challenging if a user is, for example, traveling and maybe using some unfamiliar Wi-Fi networks or that sort of thing. But I'd also say one of the problems, and I think many of you asked questions about this, it's not even relevant under the laws. This bill is currently drafted where the poster is, because it applies to anyone who might want to receive that post. And certainly plaintiffs' lawyers would be able to find someone in Georgia who would likely be willing to be a plaintiff who says that they would have liked to have seen a particular piece of content.
Okay. And is it true or not true that right now the companies probably aren't retaining location data because there's no purpose to, correct?
I would say, well, speech and Section 230 issues have been very popular issues in state assemblies around the country. Privacy issues have been as well. And so companies are being regulated increasingly on how much information they collect about consumers and how long they retain it. And so I know there's a big push on companies to retain less and less, and also to not, if they need to retain information about where users, their audience may be, not to keep that information associated with an individual user in order to give greater privacy protection.
All right, thanks.
All right, thank you very much for appearing today.
Thank you.
Next up is Frank Morris, who's here in person. Frank, if you want to come on up.
Mr. Chairman.
While you're sitting down, Mr. Morris, there are some letters also in the folders from interested groups that wanted to provide written testimony today, if anybody wants to review those as well. So thank you for being here, Mr. Morris, and we'll hear from you at this time.
Thank you, Chairman, Administration, and members of the Judiciary Committee. I'm Frank Morris, and I'm representing the Technology Association of Georgia, which is a statewide organization representing 30,000 Georgians employed in the tech space. And respectfully, TAG is in opposition to Senate Bill 393. And you've heard some great arguments and questions from attorneys that have thought and spent more time about this than I will. I'll just mention a couple of things and then get out of the way and let some of the other smart folks talk about their concerns about the legislation. So you could make the argument that under the bill, members of TAG would be forced to stop monitoring and removing harmful content, fearing exposure to liability. And we do agree that Georgia should encourage social media platforms to have content policies as they govern the removal of content such as bullying, harassment, and pornography. And it's our belief instead that Senate Bill 393 creates an incentive for companies to not prohibit and remove any objectionable content in order to avoid being accused of violating provisions of this bill and maybe being victims of large class action suits. Who knows what could happen. This bill only allows social media platforms the ability to remove harmful content that is specifically authorized to be removed by federal law or unlawful expressions, including expressions that unlawfully harass individuals or unlawfully incite violence. Our members are committed to keeping their users safe online, which is why they review millions of pieces of content every day in order to remove harmful content that conflicts with these policies, their policies. For this reason, and more that you're going to hear from the speakers that follow me, they're extremely qualified and knowledgeable about free speech issues. TAG opposes 393, and we appreciate your consideration.
Representative Walensky has a question for you.
Thank you, Chair. I don't know if you're the right person to ask, but I just
Probably
thought about
not,
this.
sir, but I'm
We're
glad
gonna,
to.
I just want to get this on the record. My understanding of what Meta, otherwise Facebook, is trying to do is go into a virtual reality space. And I'm just thinking of this bill, the way it's written, when Meta gets there, which could be in the next 10 years, where we are literally, 20 years, shopping in a virtual reality space, how this will affect that. And can you answer that question? It wasn't a question, but I just want to get that out there. That's a very interesting thought when we're just dealing with this type of legislation.
I appreciate how your mind works, sir, but I'm not the person to answer that question.
Thank you.
We will certainly not be holding judiciary meetings in a virtual reality space. It will be in person. I know that, as long as I'm chair. All right. Thank you so much for being here
Appreciate
today.
it.
All right. Next, we will hear from Chris Marchese, I believe. I apologize. Yeah. If you'd come on up, and when you're set, just introduce yourself and then tell us anything you'd like to share.
Mr. Chairman, members of the committee, my name is Chris Marchese, and I am counsel for NetChoice, a tech trade association based in Washington, D.C. Our motto is that we try to keep the internet safe for free expression and free enterprise. And that is why I'm here today, because this bill, unfortunately, though well-intentioned, actually does neither. It hurts free speech and it hurts free enterprise. There are tons of reasons why that is, but based on the questions so far, I'll just give some background in our Florida and Texas lawsuits and then proceed to the actual bill. I think that might be really helpful. So first, like has been mentioned, NetChoice, the nonprofit I'm with, trade association that I'm with, we sued the states of Texas and Florida. Those are proceeding through the court system. We won an injunction in Florida and another injunction in Texas. That means two separate federal courts agreed that these types of provisions are unconstitutional. Those are up for review at the Fifth Circuit, which will be sometime between May 9th and May 11th, so relatively soon. And at the 11th Circuit, which of course includes Georgia, that will be held at the end of this month, or the end of April, April 28th. So I highly recommend that to the extent possible, the committee try to wait for that hearing. I understand that an opinion will probably take several weeks after the hearing itself, but I think by the summer we will have a resolution to some of these questions, and I think that that will save Georgia taxpayers a ton of money and frustration, especially given the fact that the 11th Circuit is in fact their appellate circuit court, meaning it's directly applicable to this state. With that background in mind, I will shift to the many unconstitutional problems in the bill. So starting first, I want to just mention that this is almost an exact carbon copy of Texas HB 20. I believe the sponsor has also been open in admitting that this is pretty similar. Interestingly, though, it is actually even more unconstitutional than Texas's bill, and here's why. This bill exempts ISP and broadband providers. Those two groups have traditionally been viewed as common carriers. To be clear, NetChoice and myself, we do not regard them as common carriers. We don't think of them that way. We don't like common carriage as a regulatory tool. But the DC Circuit Court of Appeal did hold that they actually are common carriers. So in this bill, which establishes common carriers for things that are not common carriage, like Facebook, but then protects actual common carriers, seems very odd. And I think that that is something that the courts are going to hone in on, just like they did in the Florida case where the Florida state legislature exempted Disney, which of course Disney is also the owner of tons of content production companies. So I think that that actually makes this bill more unconstitutional than Texas. But moving on from that, the biggest problem and the reason why this bill in its form cannot work even with amendments is because it is premised on the idea that state lawmakers or the government in general can just declare certain private businesses common carriers and impose on them obligations. It is true that common carriage is an American doctrine, right? It's a legal doctrine. It comes from England. But the most important thing with common carriage is that it is viewed almost as a form of promissory estoppel, contract law. If you say one thing and other people rely on your statement, you should be held accountable for what you said. So common carriage says, if you promise that you will give equal service to everybody, regardless of what they post or what, who they are or whatever, then you can be held accountable for that promise. No social media company in America has ever made that promise. And the reason why is because the entire premise of social media is that you're going to have a curated experience. You're going to put stuff onto a website, and that website is going to help organize and screen that content so that you have a more useful, valuable user experience. And it is precisely because websites do that type of curation that they can't possibly be common carriers. And the Supreme Court has been very clear on that if you engage in editorial decision making, whether that's, like a newspaper choosing which op-eds to run, or it's like Facebook and Google deciding, what is hate speech for their purposes, that's all editorial judgment. But even if that weren't the case and that these companies could somehow be held as common carriers, they still have First Amendment rights, as proven by the Turner case. In fact, the Turner case, I forget who asked about it, but it has a very interesting posture where it was up and down from the Supreme Court back to the lower courts, and it took like 10 years to resolve. But basically, Turner said, yeah, the cable companies are common carriers, but they have First Amendment rights. And it went on to say that the reason why they're common carriers is because there is a scarce amount of spectrum for cable providers and the broadcasters that own them, right? There was a scarcity element. There's only so many channels, I guess in 1996, that you can have. Today, we clearly do not have that problem with the internet, right? There is no scarce resource with the internet. You can keep creating more and more websites if you want. And it's precisely because there are all these private options out there that the government can't come in and say, actually, Facebook, we think you are so important to the public interest, so important to the First Amendment, that you have to be open to everybody and you have to moderate the way we, the government, see fit. That is so blatantly unconstitutional that the only way to try to save it is through the common carriage doctrine, which does not apply. And because that is the premise of the entire bill, I do not think amendments here or there are going to fix the unconstitutionality of this. But NetChoice would love to work with anybody who is interested in trying to come up with a constitutional way to ensure that users are getting the experience that they want and that they deserve. We're happy to work with you all. But otherwise, I can keep going down the list of unconstitutional problems because I have about another 20.
Well, I think there are a few questions. Maybe if I could begin with the premise here is I'm not an expert on social network options or different things like that, but wouldn't you agree that there are certain go-to social networks for common use for the public? If you're looking for media streaming, video streaming, there's a social network for that. Maybe for a short message post, there's a go-to social network for that. For posting pictures, there's a social network for that. Would you agree that there are certain social networks out there that are really associated with a certain type of communication on the internet?
So like a typical lawyer, I'll say it depends, or yes and no. Yes, I think that we can all agree that there are certain websites that we use more frequently than others. I myself happen to go to Google search for all of my search things. I don't really use DuckDuckGo or the other competitors. That being said, the reason why I'm reluctant to fully agree is because I think the way that we use and engage with content on the internet really does vary by individuals. So for example, I think that the reason why Facebook was so successful and so popular in the United States was because it was the first major platform to figure out how to make an enjoyable user experience that was simple. And I don't mean to be ageist by any means, but like my parents were able to figure out Facebook, and I think that was a big appeal. Today, however, we have TikTok, Snapchat, and tons of other platforms that my parents would never use. They don't want to use it, they have no interest in learning how to use it, so they stick with Facebook. But younger generations are moving towards Snapchat and TikTok. In fact, they are overwhelmingly choosing those two options over Facebook. All of which is to say, I think that as we look at individual consumers and how tastes and preferences are evolving, especially with the introduction of innovation and Web 3.0, I just don't think that we can make enough generalities for the legislature to be on firm footing to say, Facebook, you are so essential to most people's lives that you must be open to everybody.
Where overwhelming choice does exist, as you said, within certain age groups, maybe there is overwhelming choice. Would you agree, maybe I'll give you a hypothetical situation. It's the week or 2 weeks before an election, and the owner of that platform makes a decision to weigh in and support one candidate over another. And because of that decision, then posts are suppressed of the opponent and supported or promoted of the candidate chosen by the platform. Do you believe that that's a problem, that where there is such a pervasive use of a platform that such a decision could be made internally with a subsequent impact on an election?
I don't necessarily see that as any scarier or worse than, say, the New York Times or Wall Street Journal editorial boards coming out with an endorsement for a candidate. That being said, if they are actively suppressing content to try to weigh in on behalf of a candidate, then yes, I would consider that to be a problem. It depends on how far they are taking their advocacy. But I will say that I think what is scariest of all is when the government tries to intervene in these speech decisions to solidify the legitimacy of elections. While I agree with that as a purpose of government and we should have good elections with fair outcomes, I also think that we need to keep Citizens United in mind, which said citizens care the most about elections. And so if they want to participate by spending money or by using their business to promote certain causes, that is their First Amendment right, whether it's 2 weeks before an election or 2 years. And I stand with that.
All right, we have a few questions. Representative Holcomb.
Thank you, Mr. Chairman. I'd be curious if you could make this easy for the members of the committee and save us time of going on Pacer. If you could get us the orders for both the Florida and Texas.
We have
case.
them here.
Oh, you do?
Yeah, we can pass those over to you right now and make you copies in the Judiciary office if you'd like.
Thank you. I think I think there's something here in terms of this issue, in that there needs to be clear rules that set forth when this can happen and when not. So I would challenge a little bit of what you said in terms of like the endorsement of the New York Times and Washington Post. The sad reality is most people aren't getting their news from those sources anymore. Most people are getting their news from social media. We could debate whether or not that's constructive or healthy or not. So I'm sensitive to the issue of how we do this and do it correctly. Nobody wants to do it in an overbroad way, but one thing that the platforms always say is that we're a platform and so just leave us alone. But it's not just a platform. There's a big role that these platforms are playing within this space, and they're extraordinarily powerful and they know it, but then they don't want any type of pushback or regulation. At least that's the perception that I get.
Thank you, Representative. I agree with you that this is an issue that is overwhelmingly important to many people throughout the country right now. I mean, earlier it was asked, are other states considering bills like this? They are. I think that Georgia is the only one that has a bill so similar to Texas's, but other states are, toying around with various ways of reforming or regulating social media. So I agree with you there, but where I think we should be careful is with this idea that the internet as it exists today is unchangeable, or that it is more likely than not going to be what the internet looks like in 5 years. I think that history has shown time and again that whenever we see these big players as being so entrenched that no one can compete with them unless the government intervenes, I think that that's been proven false. The big example, of course, is MySpace, which Facebook kicked off the #1 spot. But then there's other companies too, like AOL was considered a huge monopoly in the 1990s, and Congress had held hearings about whether or not to do something about it, and now it turns out nobody uses AOL. I mean, it still exists, but I don't think anybody uses it.
That's fair. Google Plus, et cetera.
Exactly. And just with Facebook, Facebook was considered this big alpha dog social media platform. I mean, it basically defined social media for a generation. And then here comes this small video service called TikTok that most people in America had never heard of before 2019, 2020. And suddenly TikTok is the most downloaded app in the country. And it's eating into Facebook's market share pretty dramatically. So I think that the platforms are going to respond to market challenges. And I think that right now, the market challenge is coming from everybody in the country saying, we are looking at how you're doing your moderation decisions, and we're not really liking what we're seeing. And I think that's going to be more than enough to get the platforms to start thinking about these issues. They've already started a private sector initiative to try to come up with best practices and principles. And some of them include, how do we communicate with our users, our expectations and our values, while also allowing them an opportunity to feel heard and to be heard. So that's a private industry initiative. And again, I think that that would get at a lot of the concerns that you and others have raised.
I hear you, but if the industry itself recognizes that there should be moderation standards, what's wrong with ultimately getting those codified?
Well, I mean, I think the biggest problem there is the First Amendment would prohibit the government from codifying them. But to the extent that the government could do that, I would also caution against it, because a one-size-fits-all approach is not going to be good for the internet or good for American consumers. For example, Facebook is the only private company that I know of that has like an external quasi-independent board that reviews Facebook's moderation decisions. I think it's working well for Facebook, but I would be reluctant to impose that on Twitter.
I understand. Okay, thanks. All right, Representative Walensky.
Thank you, Chair. Hearing Chair and Representative Holcomb, it is a very complex issue. It sounds like we have a double-edged sword. If we allow social media platforms to ban whoever they want, they are controlling the narrative, possibly. But then if we do a bill like this or something that seems broad, then maybe I'm wrong, but a country that's not here, or people who are hired by that country, could get on those platforms and say they're doing political speech and take over those platforms with misinformation for one party or the other, and then we're in the same situation where the platform is being used to affect the election. So it seems like we're in a very difficult situation. The question is, do we want to pass a law? Obviously. So common carriers, I Googled, says that they sell services to everybody on the same terms. Has that changed over time, or is that usually how common carriers are defined?
So that is an element of it. I think the other component is that they had to have held themselves out to the public as operating on a non-discriminatory basis. So this is like, the railroad saying, as long as you're willing to pay the ticket fee and abide by our conduct rules on the railroad, everybody can ride on it. That would be common carriage, where our members have said, no, you have to, you don't necessarily have to pay a fee, although there are theories about whether or not you pay fees with your time and attention and so forth. But anyway, the point is, it's not really common carriage, because none of our members have ever said, we will host your speech on a non-discriminatory basis. They have said, we will host your speech that complies with our rules, and our rules are very explicit about what types of conduct is and is not allowed. Now, granted, there's always gray areas that come up in new situations where the companies have to react super quickly. But
So, I mean, that's the hard thing for me. It seems it gets complicated when we say that all social media platforms are selling services on the same terms. That's confusing to me. And just one more thing, when the senator spoke, he mentioned a case about cable channels.
Turner.
Okay, Turner. Is Turner a common carrier?
Not really.
Okay.
Sort of.
I'll let y'all connect offline on that to
Okay.
get an answer on that. We have a hard stop at 3 today for non-civil. All right, Chairman
follow up.
Burchett.
Thank you, Mr. Chairman. Thank you for your testimony. I just have a couple quick questions. Do you think that Facebook is a common carrier?
No.
No. Why is that?
I do not believe that any social media business or tech businesses that have been mentioned here today are common carriers, because all of them have a core product or service that involves them using their editorial discretion. So like when YouTube recommends video clips, that is using editorial discretion protected by the First Amendment. When Facebook recommends my friend's photos to the top of my feed, that is editorial discretion. And so because all of these companies do that, and because all of these actions are the actual product itself, they're not, some ancillary issue, they're the core product, I just don't see how you can possibly claim they're common carriers that don't engage. In fact, if you'll permit me for 1 second, this entire bill is evidence that they are not common carriers, because this bill prohibits them from engaging in editorial discretion. So if the complaint is that they engage in editorial discretion, but we don't like how they're engaging in it, so we have to pass this law, well, then the law has already self-defeated itself, because it admits that they are not common carriers.
Very good. So I just Googled where we're sitting here. There are 295 million U.S. users of Facebook this year. I think there's, 300 some million users, 300 million citizens in the United States, 330, something like that.
Something like
So
310.
do you think for a small number of people to be able to control that much narrative or messaging, you don't think that that is taking on the role of the public square?
No, and I would also fight back a little bit on this idea that they control the public narrative. I think, obviously social media platforms play a role in how we discuss political issues in this country. And, it probably is true that most Americans are getting a large amount of their news from social media. But I don't believe that the social media companies come anywhere near a level that we need to be concerned about.
Very good. Let me stop right there. Sorry, I didn't mean to interrupt. But so if someone posts something they believe to be true, and it may be true, but I don't know what Facebook calls it. They fact-checked it. They fact-checked it, and fact-checker says not true, but it is true. Is that not them controlling the narrative?
Well, in terms of Facebook moderating its own website, yes, it is operating its own control or exercising its own control, which I think is appropriate. I took your question to mean, are they controlling the narrative beyond their own realms? So my apologies. I thought you were talking about like the U.S. as a...
Yeah, and I think that's another great point, is if their realm is more than 90% of the population of the United States, that, to me, it seems takes on the public role of the town square. I mean, that many people are using this platform every day to not only communicate, but get their news. And if you take a news article and you read it, and then you repost it, share it, whatever, and then you're sort of censored to say, well, this is not even a true news article. To me, that's them dictating what the narrative is. Is that not the case?
No, I think in that scenario, you would actually say it is an example of Facebook exercising its own free speech to contribute to the conversation, right? So if Facebook thinks that a user's speech is so defamatory or potentially wrong that it deserves a flag for readers, that's Facebook introducing its own speech, and Facebook would be liable for whatever it writes about that speech. So if Facebook marks something as defamatory and it's not defamatory, Facebook itself could be sued for defamation for claiming that somebody else defamed somebody else. But no, I'm not too worried about it, because Americans are getting the opportunities to speak your mind in this country and to hear other people speak their minds is still very high. Granted, there is an attack on our free speech culture, and I am very worried about where society is going on free speech issues. But the big tech platforms, Facebook included, they are not part of the problem. In fact, I would say, and take me at my word here, I think that they are part of the solution, because they are increasing the opportunities for Americans who traditionally would be left out of the public space to contribute their thoughts, to link up with others who believe with them. I mean, the Knight Foundation came out with a survey last week that shows that 68% of Americans are more active in politics because of social media. It gets them to show up on election day.
Very good. And then one more point I want to make, if you would oblige me, Mr. Chairman. 295 users of Facebook. Facebook also owns Instagram, 138 million users. And these are just U.S. users, not worldwide users. And then I know we mentioned TikTok. My son's a big fan of TikTok, by the way. And I'm a big fan of all of these platforms. I think you're right. It does stimulate conversation. I do believe that we're weighing the difference between a user's First Amendment right and a platform's First Amendment right. And I think this conversation is worthwhile having, and I think they're doing it on a federal level, and obviously the Supreme Court's weighed in on it. So TikTok's moved to 78 million. I would still say that is a significant ways from eating into Facebook being the largest social networking site. Would you agree?
Yeah, I think Facebook, if it's not the largest, it's one of the largest or most popular in the U.S.
Okay.
Yeah.
Thank you for your testimony. It's been super helpful.
Representative Evans.
Thank you, Mr. Chairman. I think I heard you just say in response to Representative Holcomb's question that Facebook or social media platforms can set their own standards about what we're going to allow and not allow, but the government can't because it would be a violation of your First Amendment. Did I understand that correctly?
It would violate the First Amendment for the government to set moderation standards, and the rights that would be violated there are those of the businesses.
So then, how do we have defamation laws? I mean, because we do limit, we moderate what anybody can say. You can't tell a lie. I can't say you've got a loathsome disease. I can't accuse you of a crime, and I can't yell fire in a crowded theater. So what's the difference between us setting some moderation standards for social media for public safety, but not what we already have? How is what we already have in law not a problem if moderation standards are a problem in your mind? What's the difference?
Sure. So on this, I'm going to defer to the quote-unquote conservative majority on the Supreme Court. The Roberts Court has made clear that when we are looking at what counts as free speech versus what is not protected as free speech, we look to historical understandings. And so defamation from the very beginning of our country has always been exempted from the First Amendment because it is not considered free speech to tell a lie about somebody else that has a tangible harm on their reputation and causes them harm. However, for everything else, we basically maintain the mantra of the government can't intervene unless it has an incredibly good reason. And that reason is not found here because the Supreme Court has actually already said in Tornillo that it is not a compelling government interest for the government to try to equalize opportunities to speak or to try to tackle media conglomerates or dominance or even monopolies. In fact, the Supreme Court went so far as to say that even if Miami Herald, which was the newspaper at issue there, was a monopoly on the entire state's media market, it still would not give Florida the right to intervene in Miami Herald's actions. And I think that, given the fact that that was decided in the 1970s and has been reaffirmed several times over by every Supreme Court made up of justices of all varying ideologies, I think it's safe to say that there won't be another exception made for the First Amendment in this context.
But you wouldn't see a problem with a state law that, or a federal law, I guess, for that matter, that set moderation standards for social media platforms that were consistent with defamation laws, which we don't even do right now. But I think based on your testimony, you would say we could. So that there are some moderation standards that that government can impose on social media platforms, just like we have on the world. Because right now you were saying, like, if Facebook puts a flag and says this might be defamatory and it's not, then you can get sued. But like if Joe Q user defames me, I can sue Joe Q, but I can't sue you for putting it up. And we could set, I think based on your testimony, you agree at least that we could set some moderation standards that would say Facebook can't allow a platform for defamation. Right now, y'all are not subject to that.
So Representative Evans, I'm sorry, I'm not sure I fully followed, but I think I understand your question. Section 230 of federal law is what protects innocent third parties from being held liable for the content that their users post. And that is the reason why Facebook is not held liable for what users post on Facebook. But it doesn't change whatsoever Facebook's own liability for what Facebook posts. So if Facebook posts a fact check and that fact check is defamatory, you can absolutely sue Facebook.
Right. So then let me use, instead of saying the state law could set moderation standards consistent with defamation, right now you would agree at least that the federal government could do that. Because if the federal government passed a law that said we can set moderation standards on Facebook so that you can keep users from posting defamation, that would take precedent over Section 230.
Well, if Congress were to repeal Section 230.
That was the question.
Yeah.
The federal government can do it.
Well, I don't think Congress can set moderation standards per se. I think Congress can create a cause of action for defamation and then allow the courts to figure out how that interacts with Section 230. In fact, that is the current system. I mean, like currently when people sue Facebook or so forth, they're doing it under, usually common law doctrine of defamation.
Well, I know our time is limited, but I think we are at least agreeing there are moderation standards that government can impose. It's really just a question of which branch can do it right now.
Sure. I think, like, for example, I think it is...
Not which branch, but which level, state versus feds.
Like, for example, I think, like, your state AG can investigate a platform for statements that they have made. Like, for example, if you publicly promise consumers that you're going to do X, Y, and Z, but you really do A, B, and C, well, that's a consumer fraud issue, right? And so that, regardless of Section 230, can be handled, but again, it's handled in that you are holding the platform accountable for what it said and didn't do, not what the government told the platform it should be doing and hasn't done. So I think you can hold private parties liable for what they do and don't do, but you can't have the government tell them what they can and can't do and then hold them liable for that.
Very productive discussion we're having. Thank you so much for your testimony today. Appreciate you being here.
Thank you, Mr.
All
Chairman.
right. So we have the sponsor of the Senate bill I'd like to invite back up. As he's coming, there was one late sign up that was after our deadline on the sheet, and I'd like to. Oh, he signed up. He potentially signed up on time. When this bill is heard again, we will make sure that witness is first out, and I apologize for that today. We just ran long. We'll make sure to give that witness a chance. All right, Senator, we'll give you the last word today.
Thank you, Mr. Chairman, members of the committee. I'll keep this brief. Thank you all for having a good, productive, intelligent discussion. I understood most of it. And also certainly thank the previous speakers for being here as well. I want to highlight just two things. The first two speakers spoke to the concept of this allowing harassment, bullying, obscenity, etc. This bill does not do that. This bill specifically allows for social media platforms to still do what Section 230 allows them to do, which is to prevent not only obscenity, but to prevent harassment as well. And then to the third speaker, who I'm pretty sure is smarter than me, a couple thoughts in response to his testimony. One, and I mentioned this earlier, we had Justice Breyer, Sotomayor, and Ginsburg. It's not Greg Dolezal saying that social media is the 21st century public square. It's the Supreme Court justices that I mentioned that are saying that. And then Justice Thomas made the case for common carriage. So again, this is not an idea that myself or legislators in Florida or Texas came up with on their own. We think that walking into a Supreme Court case, we start 1-0, which is a better place of starting than 0-1, which is where my friend that spoke earlier will be starting from. And thank you, Representative, for bringing up the ubiquitous nature of the large social media companies that would fall under this bill. And Representative Evans really stumbled upon what I mentioned earlier, which is that the social media companies, while arguing for the protections of 230, we're just innocent third parties, were the words that he used. But we also should be able to control the content. So don't hold us liable, and we're going to claim the 230 protection because we're not publishers, but don't tell us what to do because we're publishers. In fact, he compared them to the New York Times and the Wall Street Post or Journal, I forget which one, which are by the very nature publishers and are not platforms of others' speech. So this does get into an interesting, I would even say fun legal question that we in our time get to explore. Look forward to continuing to work through this with the committee. And Mr. Chairman, thank you for your time today.
Well, thank you, Senator, for your presentation. I want to thank the members of the committee for their participation.